Hi, everybody. Welcome. Great to see everybody. It's Wednesday. Welcome to True Crime Wednesday. We have a few things to talk about tonight. So, welcome. I'm just going to sort of let everybody catch up since I try and sign on right at 7, and hopefully everybody will catch up. For those of you who might not know me, my name is Lori Hellis. There it is, up in print. Uh, I am a retired criminal attorney with 27 years of experience and have been writing a book about the Vallow and Daybell case. And here on True Crime Wednesdays, we talk about all things true crime. It's actually been a little bit of a quiet week this week. But I have a story that I want to share with you. And I need to pull up a picture to share with you. So I have a story that starts way back in 2007 when I was called and asked to take a case for a client who had just fired her prior lawyer. So that's never a good sign. And she was in custody in the local jail, and I was asked to go down and meet her and start representing her. Her name was Nancy. So I got down to the jail, and I went to the lawyer conference rooms, which are little cubicles with glass and a telephone in between where lawyers can talk to their clients in private. And this woman was sitting across from me through the glass. She had her arms folded and she was mad as a wet hen. She was not having it. So I didn't have a lot of information about the case. What I had was her indictment, which said that she had been indicted for driving the getaway car in an armed robbery. So there she is sitting behind the glass with her arms folded, and she doesn't look like a happy camper. And so I'm very quickly trying to go through the initial police reports that I've just been handed, looking through things. It is evident that there is surveillance video footage of her sitting in the car and driving the getaway car for an armed robbery at a local convenience store. Now, Bend, Oregon is not a large town, and so everybody pretty much knows that this crime has happened. And she's sitting there. She is detoxing from meth. She's quite thin. She has been making money helping sell drugs as well as dancing at the local strip club. And she's pretty much at rock bottom. She has 3 children, none of whom she has custody of at that point. And she is a complete and utter mess. Not only is she a mess, but she is a mad mess. So we start to talk about the case, and she folds her arms and she looks at me and she says, "I can't go down for this. I can't go to prison." And I kind of leaned forward in my chair and I said, "Look, I'm a good attorney, but I'm not that good because I'm not a magician. I don't have a magic wand and I can't fix this. If I had a magic wand, we'd be in Tahiti drinking rum drinks on the beach. And instead of in Bend in the middle of winter." And she kind of sat back a bit, and I said, "Look, at this point, you are facing a mandatory 8-year prison sentence, and it doesn't look good." So over the next few weeks, we got to know one another better, and I was actually able to negotiate with the district attorney for a 3-year non-mandatory sentence agreement. In Oregon, like in a lot of states, a lot of violent crime or serious crimes carry a mandatory sentence. Part of that mandatory sentence is no time off for good time, no eligibility for any prison programs, and you serve your day-for-day sentence. And the sentences are pretty long. So the mandatory sentence for armed robbery was 8 years, not quite 8 years, a little under. And I was able to negotiate a deal for her to get 3 years and to be eligible for good time, eligible for programs while she was in prison. And, to be honest, it was a pretty good deal. And so I went back to her and I said, here's the deal. And she said, I can't go to prison for 3 years. And I said, look, this is much better than 8 years, 3 years with time off for good behavior and time off for being participating in drug and alcohol programs. All of those things are available. So finally, I said to her, the fact that you are going to go to prison is not up for discussion. The only question really is what you're going to do with that time you're in prison. You can make the best of it, treat it like boot camp, get yourself in shape, get yourself clean, and learn everything you can while you are in there. Or it can be the worst 3 years of your life and you can come out having gained nothing. It's your choice. It's not my choice. I can just encourage you to do whatever you can to make the best of the time that you're going to be there. Because the time is going to pass anyway. The only question is, what are you going to do with it? And at the time, she sort of huffed and folded her arms and said, yeah, right. And she was absolutely right. It was easy for me to say that because I wasn't the one who was going to go do the time. So because she also had kids that were in child welfare custody, I was still involved in her case the whole time she was in prison. So we stayed in contact and we continued on. And I made appearances in her child welfare cases. And I was really pleased to hear that she was doing some of the things that I recommended. Now, I want to be clear. I probably gave that speech to 100 people. This woman was the only one who really took it to heart. So all I did was run my mouth. She's the one who went to prison, did the hard work while she was in prison, did the drug treatment, did the education programs, did the job education programs, learned to be a barista. She did all the things. And because she was really a model prisoner, she also excelled at her drug and alcohol treatment program in prison. She was released on an early furlough, where she was released to a halfway house. She got out and she continued to do all the things. She went and did her aftercare. She lived in transitional housing. She got a little job working at a call center. She applied for community college and went to community college and got an accounting degree. And all through it all, she simply was looking to see what's the next little thing that I can do. She didn't, I think ultimately she looked down the road and had some goals, but I think she understood that looking that far down the road was daunting. And so often she just looked to the next moment, the next thing that she could do, making a right choice. As a result, she got a college degree. And while she was doing that, she discovered that even with a college degree, if you had a felony on your record, it was very, very difficult to get a job, to find housing. So she managed, with some help and support of her family, to buy a business. And she bought a local Anytime Fitness gym. And she still owns the gym, which she has been running and working. They managed to weather COVID, all the shutdowns associated with COVID. But in addition, she started an organization called Opportunity Oregon, and she goes into the prisons and gives educational seminars on transition from prison to work. And Opportunity Oregon does employment placement and is an employment agency for people who are coming out of prison. And it has been wildly successful. So she is at this point in all of the Oregon prisons and hoping to expand into the federal system, and really hoping at some point to take her program nationwide. It's an amazing program, and she has been wildly successful. But she has this level of commitment that you can't believe. So she has come in 17 years. She was here because just on the other side of the Oregon and Idaho border, there are a couple of men's prisons, and she was here doing presentations. Boise is the closest airport to fly into for those prisons, and she was here presenting her program to folks in the prison, the male prisons here. It has been successful beyond her wildest dreams, and I am so incredibly proud of her. A really big thing happened for her this year. The state of Oregon passed some legislation which allowed people who have felony convictions under some circumstances to have their felonies expunged. This has not been an option for felons in the state of Oregon, and is not an option in most states. So she was able, with the support of her former parole officers, with the full support of the district attorney's office, with letters of support from her former lawyer and the full support of her current lawyer, she was able to present to the court in Bend all of the things that she has done to be rehabilitated, and all of the things that she has done to be a model citizen. And as a result, her felony was expunged. And when we had lunch today, she was like, I can't believe it. After all of this time, I can have a passport. I can travel outside the country. I could own a gun if I wanted to. She's not one of those people who's too thrilled about owning a gun, but she was excited when her dad said, "Let's go to the shooting range," because it was just something she never thought she would have the freedom to do. And I am so proud of her. I am going to add a link to Nancy's organization in our show notes. And I would urge all of you to support her in any way you can. She is really in the place of beginning to expand their services. They're swamped with people who are coming out of prison and are looking for help finding employment. We know that the recidivism rate for people who find employment quickly coming out of prison, it drops dramatically. People who are connected to their community, connected to work, are much less likely to reoffend. then people who are coming out of prison who don't have any kind of a support system and who end up connecting back up with the same people that got them in trouble to begin with. So I would just urge all of you to support her in whatever way you can. Let me see. I am getting a text. Nancy is in the chat. Hi, Nancy. I am so proud of you. I was so excited to have lunch with Nancy today, and we have been connecting and staying connected ever since that day 17 years ago, and since I retired. And so I am so incredibly proud of her. I just let her know that I'm going to be moving back to Oregon. And I hope that I'm going to be able to help her out in some tangible ways. I've done a little grant writing, so they're working on some new grants, and I told her I'd be happy to help with that. I've also applied to reactivate my law license in Oregon, strictly to do volunteer and pro bono work. And I'm hoping to do some more of that one once I'm back in Oregon. So I'm really excited. I'm excited for Nancy. I will admit that I didn't spend my Wednesday prepping for tonight like I usually do, because I was absolutely overjoyed to spend a couple of hours over lunch with Nancy. So please let her know in the chat how amazing she is. And I am absolutely honored to call Nancy my friend, and super proud of her. So, and I want to point out that she could not have accomplished all of the things that she has done without a tremendous amount of support, both from her community and from her family. And I'm super proud of them as well. So she's tearing it up. She's a city leader on a couple of governmental commissions, and toying with the idea of running for office. And I think she would be an amazing elected official. So I'm proud of you, Nance Pance, and so happy I got to spend some time with you today. A couple other things that I want to talk about today before we dive into the few things that have happened in the true crime world. I want to let everybody know that there won't be a show next week because I'm going to be traveling, heading to Bend to start doing a little house hunting, and meeting my daughter and her husband there. So that's all exciting stuff. So nothing next week. I also want to remind you that the book is available for pre-order on all of the places where you regularly order books, whether it's Amazon, Barnes & Noble, bookstore, or available from your local independent bookseller, and available for pre-order. I'm actually starting to book book signing events, so I'm really excited about that. We are going to be at CRIMECON. CRIMECON happens in Nashville, Tennessee, from May, don't get my dates wrong, May 30th through June 1st. It is an amazing event. If you happen to be in the local area, I hope that you will join us. It gets bigger every year, and every year we have more folks, more creators, more interesting seminars and educational committees, and I mean it just gets bigger every year. So if you are able, we'd love to see you there. I know I've talked to several people recently. My friend Julie, who's from here in Boise, is going to go and has offered to give us a hand in the Good Lori booth. And so my daughter's coming down. I'm looking forward to having some time to meet and greet and show off and hand out a little swag and sign some book plates in advance. So um, there will be much more coming. I finally connected with my wonderful IT guy who is working on our book launch website. We're hoping that's going to be live next week. The first 100 people who sign up, I will get information out on the YouTube community channel, as well as in my newsletter. I will send out a newsletter about the book launch events that are coming up. And I will get that information out to everybody with a link where you can go, because the first 100 people who pre-order the book and sign up on the website will get an advanced digital copy of the book and some other fun benefits, some individual things that we're going to do, some launch team only events that we're going to do, some one-on-one Zoom calls, all of those things. And in return, we're hoping that you will take a few moments and post a review of the book and post a picture of yourself on social media with it once the book is available in September. So we're hoping that the 100 people who sign up will commit to posting a review. Reviews are, in this online day and age, reviews are super important. If you get to 60 reviews on Amazon, you then end up in the sales funnel. The algorithm starts picking up the book and promoting it beyond what I'm promoting. So we're going to be super excited to offer all those things and to offer advanced copies, to get them out to you so that you can give us an honest review. So that'll be coming, I hope, next week, within 2 weeks for sure. But the young man who does my IT work, is a friend of my daughter's that she met at her first advertising job. And the IT work he does is a little bit of a side gig, and he's got two little babies. So we're a little more patient when we're working with folks who have other jobs and other things going on. But he's promised me that he'll get it done for me really soon. He's the one who takes care of my other websites and the site where all of the newsletters post. So we're looking forward to getting all that together. Now, let's talk a little bit about what's been going on in the true crime world. Brian Kohberger had a hearing today, and it was, to some extent, technical. And I'm sure that there were a lot of people who tuned in to watch it and thought, oh my God, what are they talking about? Because a lot of it really was technical, and some of it had to do with documents and other things that are sealed, which made it even more cryptic, I guess. It was a little hard to follow at times. So I thought I would just run through a quick review of it, because there were several issues before Judge. Can you believe his name is Judge? That's like the urologist whose name is Dr. Tinkle. Judge, it seems very appropriate, is appropriately named. So one of the things that was on today was the judge asked about what was happening with an interlocutory appeal that Kohberger's team filed. Now, for those of you who've been following me along for a while, we've talked about interlocutory appeals before. I'm going to warn you, allergy season has begun in Idaho already, and I have a runny nose, so I apologize in advance. But this is me on 2 different kinds of antihistamines and Flonase, so I try my best. But an interlocutory appeal is an appeal of a judge's order, usually an evidentiary order, prior to trial. So it's a pre-trial appeal. we talked about this at length on the when we talked about the Delphi case. Debbie Biggs, that is so generous of you. Thank you so much. You are so kind. We know there's going to be an audiobook. I don't know who the narrator will be. My publisher hasn't had that conversation with me yet. But some authors narrate their own books. I'm not really set one way or the other. I mean, if they asked me, I guess I would do it. I've never done one, so that would be a whole new learning curve. But I'd be okay with somebody else doing the narration as well. But thank you so much, Debbie Biggs. You are so generous, and I do appreciate you. So interlocutory appeals are appeals that are filed because they preserve an issue that, if it's not decided before trial, could prejudice the defendant. So in Delphi, one of the interlocutory appeals was the court's order ordering the two attorneys off the case. The other interlocutory appeals were replacing the judge or recusing the judge. So they were able to get that to the Supreme Court because the Supreme Court found that there was no other alternative for them. If they were to wait until after the trial was over, there would be irreparable harm that a post-trial appeal wouldn't fix, couldn't cure. So the issue in the Kohberger case is the motion to dismiss the indictment. Now, most of the discussion and the hearings around that issue were sealed because it had to do with the grand jury, and grand jury proceedings and anything having to do with the grand jury is secret. So that was what got a little confusing, trying to figure out what it is that they're trying to get the Supreme Court to weigh in on when it's all sealed. So what we know is that the defense filed their appeal. The state attorney general, not the local prosecution, but the state attorney general filed a response. And they are waiting to determine whether or not the appellate court is going to take it up, and if so, when those oral arguments might happen. So what's going on right now is that the appellate action does not stay the current trial court activities. It would only stay those activities if the appellate court said, yes, we're going to take it up. But at this point, the court hasn't made a decision yet, so there's no reading on that. So the next thing, and I'm going to circle back because probably the most widely discussed were the change of venue motion and a trial date, and those two kind of things kind of dovetailed together. So I'm going to go back to those in a minute. The other issue was the release of the IgG information. That is the DNA genetic genealogy, the investigative genetic genealogy issue. Now, the defense has wanted all along to know where that information came from, which DNA site it came from, and how it was used to identify Brian Kohberger. And that's not entirely clear. And so the defense is trying to get that information to understand the process that the FBI went through in using that information. Now, what we know from the probable cause affidavit is there were like parallel investigations going on. They had the knife sheath that had DNA on it, the assailant's DNA. They also had CCTV footage or Ring camera footage and Department of Transportation red light footage, all of that stuff they had put together led them to believe that a white Hyundai Elantra was a suspect vehicle. So they had those two pieces of information. And they were running these parallel investigations. They were looking for this white Elantra. They were also looking for whoever matched the DNA on the knife sheath. And several things happened all sort of in really close proximity. And I don't think it's entirely clear how it all came together. A white Elantra was identified as belonging to a student at Washington State University, just across the border from Moscow in Pullman, Washington. And there was there was also this looking for a DNA match to the person, or at least a family member of the person who was the depositor on the knife sheath. So those two things were sort of running parallel. In very close order, it was discovered that Brian Kohberger owned a white Elantra, and discovered that there was a familial connection to Kohberger, to the DNA. So those two things together led them to get a warrant. Now they knew that Kohberger was driving cross country with his father. His father, it was Christmas holidays. His father had flown out to presumably to Boise. That's probably the closest airport, maybe Spokane, and was driving back cross country with Brian Kohberger in Kohberger's white Elantra. And so law enforcement was keeping track of them as they were traveling cross country. Once they arrived at his home in Pennsylvania, let's stop for a minute. They then collected garbage from the trash can out on the curb and were able to recover DNA from the trash that matched Brian Kohberger's father. So they knew that, and they knew that the DNA that they had found on the sheath had a familial match to the DNA they found in the garbage can. Now, none of that had to do with the IgG looking for somebody in the genetic databases. It didn't have anything to do with that, because what they did was they compared the profile that they found on the sheath, connected it up through the white Elantra, said it's possible that somebody in that house is related to the depositor on the sheath, and lo and behold, they came up with a familial match. So that didn't have anything to do with genetic family tree, with creating a family tree and connecting up people with these remote genetic connections. So it's not 100% clear how that connection happened, which is what the defense wants to know. They know IgG was used. They just don't know where it fit in that process of, they did not know where it would fit in that process of connecting up those dots as they went along. Okay. Just as you have to connect circumstantial evidence at trial, that connection begins with law enforcement's investigation. So they're slowly and methodically trying to connect up those circumstantial dots until they lead to a conclusion. So the defense still doesn't know really how the state, how the investigation, the government, the FBI, law enforcement used that IgG, that investigative genealogical DNA, genetic genealogy, how that they still don't really understand how that piece came into the investigation. And they've been trying for months to get the judge to force the prosecution to provide that information. Now, remember that the defense has the right to investigate any leads that might come from information produced by the state. They don't just have the right to the information, but they have a right to chase down any leads that might come from that information. So the prosecution kept saying, we didn't use this to connect Brian Kohberger to the knife sheath. We didn't make a positive ID until after he was arrested and we did a cheek swab and we were able to establish that it was in fact him that deposited the DNA on the knife sheath. The problem has been that the defense keeps saying, but whoa, wait a minute. How did you get to Brian Kohberger? Did you get to Brian Kohberger? Did you identify Brian Kohberger because of some familial match through the IgG? The prosecution has said they didn't, but they have not been willing to produce all of the documents that would back that up. So they've gone round and round. Judge has now ordered that he ordered an in-camera review, meaning he reviewed in privately. In camera usually means in chambers. He reviewed all of that evidence and then made a determination of what he thought was relevant to the defense and what he thought they needed that needed to be released to them. And so not all of that information has yet been released to the defense. They're still working on getting all that information. But ultimately, the defense is going to get that information and be able to vet it with their experts and their investigators and be able to determine whether or not that investigative genetic genealogy, that building that family tree, had anything to do with the way that they identified Brian Kohberger. Now, the reason why this is perhaps an issue is because there are only 2 of the databases that allow law enforcement searches. The rest of them, and the 2 biggest, 23andMe and Ancestry.com, their terms of use strictly prohibit law enforcement from using their database to identify potential criminals and to identify and find defendants. So they specifically say you can't do that. However, there have been cases where law enforcement have signed in created profiles anonymously and have searched those off-limits databases, even though the law enforcement policy, FBI policy, law enforcement policy is that you honor those third-party agreements and that you do not use those sites. So the defense has a decent question to ask, and that is, they know that when they ran the DNA through the FBI system, it came up with no hits. That's because the FBI system only records people who have been convicted of crimes or missing persons. So there is no way to link up somebody who doesn't have a prior criminal history. And in most states, they don't take DNA unless it's a felony. So the guy who gets a ticket or gets a DUI is not going to be not necessarily going to be in the DNA database for a criminal conviction. So we knew from the probable cause affidavit that Brian Kohberger did not show up in that database. So if Brian Kohberger was identified by a familial connection, it was through a different database. Now, there are databases that that people can upload their DNA data to, and it is available for law enforcement to search. But they are much smaller databases because you have to opt into them. They're much smaller databases than the Ancestry and 23andMe. So the likelihood that you're actually going to get a match is much lower. So it's a reasonable question for the defense to be asking whether or not they observed the rules or whether they fudged the rules and anonymously searched the databases that they're not allowed to search. The reason that's important is because if that IgG is in any way associated with connecting up the crime with Brian Kohberger, then it could be that information gets kept out as fruit of the poisonous tree. Because if law enforcement illegally obtains information or evidence, anything that then comes out of that evidence becomes suppressed because it becomes what we in the business call fruit of the poisonous tree. If the tree is poison, the fruit is poison. So that's the argument. So it still has not been resolved. One of the issues was that the judge issued a protective order, and in the protective order, he didn't specifically name people who were allowed the investigative staff who were allowed access to the information. And the state came back and said, we need them to be specifically named, even though in prior gag orders, orders, they have not been named specifically. They've just said, the defense investigators. So the other thing that the defense wanted to make very clear was that none of this information having to do with DNA was in any way involved in the mitigation investigators' work, and that the investigator in charge of mitigation was doing her own independent investigation, and that it had nothing to do with the mitigation expert is going to look at family ties. She's going to look at family connections, at how this person's family life was, and they literally go back 3 generations. That's the ABA best practice standard. And so the mitigation specialist is going to build their own family tree and figure out where everybody fits in relation to the defendant. But that is not an IgG investigation. And so the defense attorney wanted to make clear that there was no investigation going to be occurring having to do with there was no connection between the DNA that the judge was allowing them to study and view and the mitigation investigation. So the next and final thing was the prosecution piped up and said, well, we need to set a trial date. And then they went round and round about what was going to be an appropriate trial date. The defense attorney, and I think rightly so, and the judge did side with her, the defense attorneys filed a motion to change venue. And just as we saw in the Vallow-Daybell case, Moscow is a very small community. Almost everyone in the community is associated some way with the college. So it's a community, it's a very close-knit community, very much focused around the university and the students. And so they were very concerned about the publicity, about all of those things, the same way they were in the Vallow-Daybell case. They were concerned about, whether or not a fair jury could be seated. Now, in the Vallow-Daybell case, they made similar arguments, and the prosecution made similar arguments that no, you can't really take up the issue of a change of venue until you're close to trial. You have to be able to prove that you can't seat a fair jury, which means that you need to question and go through the voir dire process in order to voir dire, some people say voir dire, process of questioning potential jurors before you can be sure that none of them can be fair. So what the defense said was making the same arguments that were made in the Vallow-Daybell case. If this case is going to move, we need to know that in advance. It is not the kind of situation where we can say, oh, okay, we'll move next week. It can't, the trial can't be scheduled that readily in Ada County. Presumably it would come to Ada County, Boise, the same way that Vallow-Daybell did. And, what they're saying is we cannot turn on a dime. You cannot schedule a trial that could take 10 weeks and just call up Ada County and say, we want to move this very high profile, lengthy trial to Ada County. How's that work out for you? So, and they're right. So they argued that we need to get ahead of the issue. So the judge kind of molded over and said he agreed that, in fact, the change of venue motion needed to be considered soon and not wait until just before trial. So the change of venue motion is going to be, the hearing on that is going to be on May 14th at 1:30. Now that gives both sides plenty of time to put together their legal arguments, their hearing memoranda, and it gives them plenty of time to do some of the work that needs to be done in the community to discover community attitudes. Oftentimes in change of venue motions, we'll see them do some walking around and surveying people and asking people questions and going to places like the DMV or grocery stores or outside the courthouse and asking people, have you heard about this case? Have you formed an opinion about whether or not this person's guilty? And really starting to take the pulse of the local community in Moscow. I think it's very clear they're going to find it is going to be very difficult to seat an unbiased jury in Moscow. And it seems to me like the sooner they make that decision, the better. Now, Judge has said, I'm not entirely convinced we can't seat a fair and impartial jury. And he started sort of starting at that starting point, which is appropriate. I think we always assume that you can seat a fair jury until information to the opposite comes out. So we'll wait to see what happens, but they have between now and May 14th to do all that legwork and to put together their presentation to the court about whether or not the case should move. I just saw a little question that in the chat, which is on this subject, so I will quickly answer it. I noticed that that Jen started, but in Idaho, as it was for the Lori Vallow case, what happens is if the judge, in this case, Judge Boyce, when in the Vallow case, once Judge Boyce issued an order saying, yes, we want to change venue, then it was up to the Supreme Court to determine what venue was going to be appropriate. And so in the Vallow-Daybell case, they found that moving it to Ada County, which is Boise, gave them the best chance of getting an unbiased jury. So the Supreme Court made the decision as to where that was going to happen. So the Supreme Court said, yes, we think Ada County is the best venue for this, the best cross-section, the best place where we might get jurors who are going to be unbiased. So what happens then is the trial judge that's assigned has an option to either ask the Supreme Court to appoint a local judge in the new venue or to stay with the case. So this is up to Judge the same way it was up to Judge Boyce. Now, Judge Boyce, who had been on the Vallow-Daybell case for a couple of years, said he wanted to stay on the case. It can be a real hardship, and Judge brought that out at the hearing today, saying, I'm not super excited about having to move from my home in Moscow, which is a considerable ways away from Boise, for 10 weeks or more to preside over this trial. But if that's what has to happen, that's what I will do. So he made it clear that he wanted to stay on the case, and that if the venue changed, he would go with the case. So, and that's probably good, because I think he has a lot of history with the case already. So then the issue of trial date came up, and they kind of dovetail together because, the prosecution's saying, we can't really hear venue until we know when the trial's going to be. The defense is saying, no, we need to decide venues so then we can set a trial date. It was an interesting discussion. The state is asking the court to set a trial the first week in March of 2025. Now, I know that seems like forever from now, but I guarantee you, from a defense attorney standpoint, that's going to go by in the blink of an eye. So the defense attorney is saying, while the prosecution has said we have provided about 90 to 95% of all of the discovery, it's huge. The defense attorney admitted she has not been through every page of the discovery yet. She just hasn't had the opportunity or the time, mostly because she's been working on all these pretrial motions, which is where she should be focusing her attention. So she said, I need the court to set a definite discovery deadline. And from that discovery deadline, I can tell you that I will, if you set a discovery deadline in August, I can be ready to go to trial in June. So the state's asking for March, she's asking for June. We'll see what the judge does with that. I think a lot of it is going to depend on the outcome of the venue motion, because if the court decides to change venue, I think probably it's going to be more like June, because they're going to have to coordinate with Ada County. They're going to have to go through all of the things that that Judge Boyce went through with the Vallow-Daybell cases. And they are going to have to coordinate with Ada County for a block of time when Ada County can make their courthouse available. So I suspect it's going to be more like June, but the judge is looking at both those dates right now, and a lot of it is going to depend on what's decided in the change of venue motion, because Judge has a lot more control over what happens in the courthouse in his own jurisdiction in Latah County than he would in Ada County, here in Boise. So that will be the next sort of interesting thing to look for, will be this change of venue motion in May, on May 14th. And I think that regardless of what the outcome is of that motion, I think the judge will at that point set a trial date and set motion and discovery deadlines. Because that's, you set those motions sort of you back up from the trial and set those deadlines. So I heard today that there was the Michelle Troconis trial has concluded and gone to the jury. They're on verdict watch. They have deliberated an hour or so the first day, all day today. And I understand that there was at least one jury question. Now, this judge, and this is something that varies along with with whether or not jurors can ask questions during a trial and those sort of things, whether jurors take notes, all of those things vary with jurisdiction. In this particular case, this judge, the judge in the Troconis case, told the jury that if they wanted to hear back any testimony, that they could. And so they asked to hear back testimony from Michelle Troconis's best friend. They clearly haven't reached a verdict, and I'm sure have gone home for the evening. So that verdict watch will continue on tomorrow. The only other really sort of big trial of note at this point is Hannah Gutierrez. This is the Rust, the movie Rust. She was the armorer on that movie set. And this is the case where Alec Baldwin pulled the trigger on what he thought was a safe gun, and it fired. It went through the director of photography, who later died of her injuries, and hit he may have been the main director, I think, on the case, on the movie. So the question has always been, there should have never been any live rounds on the set. They used dummy rounds. Now, what they've explained is a dummy round. The guns that they are using are replicas of old guns. This was an Old West movie. Reported to have been fairly low budget, which is an issue in the case. Hannah Gutierrez was the armorer on the case, so the person responsible for all the guns. Her father is a very well-known and very well-respected armorer in Hollywood, who has worked on some of the biggest shows and movies and TV shows out there. He was the armorer on The Walking Dead, so he's the real deal. She was a young woman who had been trained by her father, worked with her father, but this was one of her first movies where she was actually the armorer and was in charge of the guns. She explained that in these guns, they use two different kinds of bullets. One are called dummy rounds. Now, what that means is they are inert rounds that could not fire. They either are rounds, and they're loaded in the guns for the purpose of the cameras. So if a gun can be seen, the camera can see the gun, they want it to look like it has bullets in it. So they load these dummy rounds, and the dummy rounds, you can tell the difference several different ways. They either have a primer that has already been fired. Okay, so that I'm not a gun expert. I tell you this all the time, but the end of the brass casing has a primer in it, and that's where the firing pin hits. and causes the explosion that ignites the gunpowder and sends the projectile out the barrel of the gun. So in these dummy rounds, they either are brass that has already been fired, but they have a dummy slug on them, so they look for the cameras, or they are rounds that have been drilled and the gunpowder drained out of them, or they are rounds that have a little BB inside. So when you shake them, you can hear that they don't have gunpowder, they rattle. So they were using dummy rounds because they were doing all the camera angles and it was a walkthrough, and they were doing rehearsals, getting ready to shoot these scenes. And the director of photography was there. She was plotting out all the camera angles, and they were preparing to shoot the scene. So they were using dummy rounds. The only other rounds that they should have been on the property were blanks. Now, blanks are a little bit different because they actually have a small gunpowder load in them, but they don't fire a projectile. They make the sound of a gun firing, okay? And so Hannah Gutierrez set up the guns. We heard testimony. We heard her police interviews. We've heard testimony from other people who were there on the set and were her assistants. They set up the guns. They were supposed to have loaded all these guns with dummy rounds. But when law enforcement went through the rounds that were on the prop cart, they discovered that there were live rounds unfired with the firing pin in play, the primer in place, and gunpowder and a projectile. They were live, real bullets because they were using real guns on the set. The law enforcement discovered that there were live rounds in with all of those dummy and blank rounds. The question is, we don't know how they got there. They were using a prop house. It was fascinating. They showed pictures of this place, this prop house, and the prop house was this it looked like a hoarder's house. It was totally disorganized. There were props everywhere, but they did show that the guns and the ammunition were secured in lockers. And it was the prop house's job to provide the physical guns and ammunition. However, Hannah Gutierrez also texted her dad and asked him for dummy rounds that she was going to take to the set. This was not a very well organized set. The prop cart was a total disaster. It was a mess. There were bullets all over. There were bandoliers. Everything was sort of piled on this prop cart. No organization to it. But there was a box that had rounds of ammunition in it that were loaded bullet down, point down. And it was very obvious that there were live rounds that had live primers. Hannah Gutierrez has said in her police interview that she was the one who loaded the dummy rounds, who handed the gun to the assistant director, who then safed the gun, handed it off to Alec Baldwin, and said, "This is a cold gun." So Alec Baldwin relied on the safety protocols that were being followed by the armorer, and there were actually 2 people who were supposed to have checked that. It appears that not all of the safety protocols were followed. When she checked, she was supposed to take every dummy round and confirm every dummy round was a dummy, either by finding the holes that were drilled in it to drain the powder out, by shaking it and being able to hear the BB rattling around, or by examining the primer on the bottom and determining that that primer had already been fired and was no longer operative. One of the people testified today that instead of shaking each round, she shook the whole box. How you would ever figure out if you had a round in there that didn't shake, I can't imagine. So there were a lot of shortcuts that were happening on the scene. That was not really known to the director or to the actors. This was happening behind the scenes. One of the reasons was because Hannah Gutierrez was also tasked with being responsible for some of the non-gun props. And that is usually not the armorer's job, but cutting corners, she was being tasked with doing some other prop management beyond just handling the guns and the ammunition. So she handed the gun off. It went to the assistant director. He supposedly checked it, and it was passed off to Alec Baldwin. Now, Alec Baldwin says, I didn't, and there was a lot of testimony about how the gun functioned and when it could be fired, when it was cocked, when it was half cocked, when it was. Emily D. Baker had a field day with all of that and with all of the sexual innuendos in it. But I think it was really unclear whether, from what the FBI said, because they test fired the gun, and then they hit it with hammers to figure out whether or not they could make it malfunction. And in doing so, they broke the gun. And now the defense is saying, well, we don't know whether there was any of that damage before the FBI got a hold of the gun or whether it was after. And you can put the gun back together and you can put a new part in it and you can make it fire, but you cannot definitively say that the damage to the gun was caused by the FBI and that it wasn't present at the time the shot was fired. So that's a big hole that is in their case. There was a lot of missteps in the evidence. And so the defense has been able to really capitalize on those missteps. I don't think those things are going to help Hannah Gutierrez because she was responsible for loading live ammunition into that gun. And I don't think it's going to save her, but it could save Alec Baldwin. So he has always said, I didn't pull the trigger, but there is footage that shows that his finger was inside the trigger guard. It wasn't off the trigger, it was inside. At this point, I think that they have made a very good case for the issue of causation. And we usually talk about causation in civil cases, but I think in this case, in order to find Alec Baldwin negligent, you have to prove that he could have that he acted recklessly or negligently in what he was doing. And I think they fall short of that because I think he had the right, or the right, if you will, to rely on the people whose responsibility it was to safe the gun. And it is so drilled in safety that you never bring live rounds on the set, that I'm sure it was outside of his even consideration that there could be a live round in the gun that he was handed to rehearse with. So I think that Hannah Gutierrez is going to be found guilty. I think she is going to be, I'm not sure she's going to get a lengthy prison sentence out of it. But I do think that she will be found guilty. I think it's interesting that there are a couple of other people, including the guy she handed the gun to, who then handed it off to Alec Baldwin, who have already pled guilty and gotten deals. I think it's a little unfortunate that she's decided to go to trial, because I think it's possible that she could have negotiated a better deal than she will get at sentencing, but we'll have to see that. So that was the two really big, interesting things. There's one other big, interesting thing that happened that I want to talk about, and that is that has to do with an Idaho case. This is an inmate. His last name is Creech, and he has been on death row for more than 30 years. And there have been death warrants that have been issued before that had to be vacated because they couldn't get the chemicals, as they call them, the drugs, in order to carry out the lethal injection execution. So, like many states, Idaho has had difficulty obtaining those drugs because most of the companies who are now who manufacture the specific drug that is used will not sell to states for the purpose of executions. So the states are reduced to getting those drugs through compounding pharmacies. So these are pharmacies who put together the component parts to make the drug that constitute the drug chemically in their own lab. They are not produced by the mainstream producers. So Idaho was able to obtain a sufficient supply of the drug that they use, pentobarbital, and from a compounding pharmacy. And they had scheduled Creech's execution for today. He was moved into the execution bay. All of the witnesses were there. His family witnesses were there, and they made 8 attempts to start an IV and find a vein. They tried both arms, they tried his hands, they tried under his arms, they tried his feet, and his ankles and behind his knees, and they were unable to start an IV. And after an hour of poking and prodding him, they canceled the execution. So now they're trying to decide whether or not the death warrant that was that they were carrying the execution out under expired today. And the warden said they would not be making another attempt today, that they would wait, and they would have to wait to secure a new death warrant. That, of course, gives his lawyers more time to ask for last-minute appeals and stays of execution. I think the last guy who they scheduled death warrants for and weren't able to carry out the execution because they couldn't get the drugs has filed an action for cruel and unusual punishment because of the repeated issuance of death warrants. And I think he may very well have a basis for a case. I think at this point the governor would be smart to commute Creech's sentence to life without parole. He's an old man. He's in his mid to late 70s. And I think it would be smart to sort of take the wind out of everyone's sails and just say, I'm going to commute his sentence. Because what's going to happen now is that the legal defenses are going to be up in arms and making all those cruel and unusual arguments. And I think they have a pretty good case. I try really hard not to get political on my channel. We haven't talked at all about the former president's legal issues, and I've tried to sort of shy away from the politics. I also have tried really hard not to infuse my own bias, but I'm a defense attorney, and I think you can draw from that I am not a supporter of the death penalty. And I believe that we spend an inordinate amount of money on these cases, millions of dollars. Lori Vallow's case, they spent almost $4 million before she ever got to trial, and then the death penalty came off the table anyway. So we know that there's going to be probably at least that much spent on Chad Daybell's trial. So it's a very expensive proposition. And that doesn't include the next 20 years of appeals, because the state's going to appoint an appellate lawyer, and the appellate lawyer is going to work to get the conviction overturned. There's going to be all this post-conviction work that will go on for years and cost millions of dollars. So there's that. I also think that if there is even a sliver of risk that we are going to execute an innocent person, I don't believe we should go forward with an execution. And I don't know of any execution that goes forward without some sliver of doubt about whether the person is innocent. And too many innocent people have been executed. The states, the political climate has moved away from the death penalty. Less than half the states now, it may be just over half, I think it's 27 states still have the death penalty. And even in those states, at least 4 of them have a moratorium on executions. My home state, Oregon, had a moratorium on executions for 10 years because of the issue of the difficulty of getting the drugs to carry out lethal injection. The outgoing Democratic governor this last gubernatorial election, as she was leaving office, she unilaterally commuted all of the sentences of all of the people on death row to life without parole. So there are no people on death row in Oregon. Oregon has not done away with the death penalty. However, there are no people on death row at this point. And I think we are seeing that trend move across the country. For example, the Montgomery case, the state of New Hampshire had just done away with the death penalty in 2019. So I think we're going to see more and more of that as people realize how costly it is and how difficult it is. Now, the state of Idaho has recently reinstated death by firing squad. However, that only applies to future convictions and not to it's not retroactive, because that would be a due process and violation of someone's rights. So you can't be tried and convicted with a punishment that you didn't expect or didn't have notice of. So that makes it a due process issue. So it will be interesting to see how they decide to go forward. The other wrinkle is that the drugs that were obtained for Creech's execution have an expiration date in May. So the clock is ticking in a lot of ways, and we'll just have to wait and see what the state of Idaho decides to do, whether they decide to continue to pursue a death warrant or not. I understand people can have very differing views of the death penalty, and it is the law of the land in 27 states, and I respect that. However, my personal opinion is that I don't believe that it is an effective deterrent, and I don't believe that it is a cost-effective way to mete out justice. So I'm ready to take questions at this point. So I'm sure I noticed that Jen has been starring questions in the chat, but if you have questions, please post them now and put capital Q's in front of it. It makes it easier for Jen to find them. Lily B, I'm confused. Didn't they identify him by family DNA from the trash? They narrowed it down to him because of his car and cameras, then retrieved the trash. So I think this is a confusion everyone shares, including, I think, the defense attorney. The trash that they used was the trash from outside his parents' home in Pennsylvania. He was already in their sights because of the car, and we think there was some sort of familial DNA connection, but we're not sure about that, and the defense isn't sure about it either. The prosecution says that it was not a familial link that brought him to their attention. It was the car, and they followed him cross country, and they got the trash, and they recovered DNA out of the trash that was his father's. And they were able to say the person who left the sheath at the crime scene is related to the person who lives in this house. And they knew that the depositor was male. And so when they got the father's DNA and they compared the two, they knew that the depositor on the sheath was the male descendant of the person whose DNA they had, the Kohberger's father. And Kohberger is the only male son. He's the only son. He has sisters. So that's how they were able to narrow it down. What the defense keeps saying is, how did this investigative genealogy come in? Because the prosecution keeps saying, this is the way we identified Kohberger. We followed the car, the white car that we thought was suspicious. He was a student in Pullman. We followed the car. We went to the house where he was staying out in Pennsylvania. We got the DNA. We compared the DNA to the depositor on the sheath and confirmed that the depositor on the sheath was the male offspring of the person who lived in that house. And that's how we connected Kohberger. Once Kohberger was arrested, we took a cheek swab. We compared that to the DNA profile of the sheath depositor, and it was a match. But somewhere along the line, there was a use of this IgG, and the defense has not been able to figure out whether or not it was actually used to connect to Kohberger. And if it was, they want to know whether or not it was legally obtained by not using the sites that don't allow law enforcement to use them. I hope that's clear. So the answer is we don't know. The prosecution claims that they didn't use that IgG to connect Kohberger to the scene, but we don't know for sure. And the defense has the right to ask those questions and get those questions answered. So Good question. Brandon, if she is convicted, how much time will she likely serve? I think this question relates to Gutierrez. My understanding is in California, negligent homicide carries up to 15 years. I could be wrong about that. But it could be less. And I don't know. I don't expect that she's going to get the max. So I think she's going to be the one who's going to go down for it because she's the one who loaded the gun. So, oh, Terry Goyens just posted. Terry is one of my favorite quilters and who did all of the long arm quilting on the True Crime quilt. And she said she is just starting to make her 1,000 crane quilt square. So let's talk about that as we wrap up a little bit later. So Jen, don't let me forget to talk about the crane. She's nodding her head. I can see her. Patter radar. Okay. As a defense attorney, would you have let her do that police interview, especially not knowing what evidence they had? Well, I think that I never advised a client to do a police interview with me or without me, but certainly never without me. I had clients in the context of having a client who was giving up information in return for immunity or in return for a reduced sentence. That in that context, I sometimes would permit a client to sit down with law enforcement with me present, and having really sort of decided what the parameters of the conversation were going to be. But I would never, ever advise a client to sit down with police and not invoke their right to remain silent. So I absolutely think her police interviews were fatal for a variety of reasons. One, because she was so darn casual about, yeah, I do this and and not, it was clear in the initial interview that she was shook up by the fact that someone had been shot. By the time she did the next interview, she was a little bit more sort of laissez-faire about it. And I think that didn't help her. So I would definitely have never, ever advised a client to undergo that kind of questioning. And, in fact, one of the reasons why the Lori Vallow trial has been as contested as it was is because neither Chad nor Lori ever talked to law enforcement. They absolutely declined from day one. And that's certainly what I always advise my clients. Hi, Ladybug Lady. I heard after they were out shooting live rounds at cans. I'm not sure if that's true. I've heard this as well. I had heard that she was out with some of the crew and they were firing live rounds, target practicing. I don't know whether that's true or not, and I haven't heard it at trial. Now, I want to say I have not listened to every minute of testimony, just because I got my edits back from my editor, and so I am working through my edits from my editor on my chapters. So I have not been following every minute of this trial. And so if it came out in testimony, I don't recall hearing it. But nonetheless, there were rounds being pulled from a variety of different places. Hannah Gutierrez had some of them in her home. She went to her dad's and got some. She got some from the prop company, which is where they all should have come from. And so she didn't know where all of those rounds came from. And it was really interesting because in her police interview that they showed at trial, she reaches in her pocket and pulls out a bunch of rounds and throws them on the table and says, well, they're like these. The police didn't even know she had bullets in her pocket. So, it was a pretty lax, it was a lax set. Safety was lax. There was a very scathing report from OSHA, from the safety inspectors. And so, and the protocols for how you keep track of ammunition and guns absolutely weren't followed. So no question of that. The question is whether Alec Baldwin is culpable for the actions of the armorer and the other person who was responsible for checking the gun for live rounds. That's going to be a bigger question at his trial, but I don't know whether he'll go to trial or not. It's going to depend on what I'm pointing over here, because I still have the YouTube window open on my other screen. It's going to depend on what happens in Hannah Gutierrez's trial. A lot of it is what comes out in the evidence at the trial, and what the outcome is. So good questions. Hi, Idaho Mom reports. I admit I am an Idaho transplant. I was not around and don't have a lot of history with any of the people who are on death row. I do not doubt for one instant that he is a master manipulator and may very well have gone without fluids. I don't know. That is certainly very possible. So I can't say for sure one way or the other, but it wouldn't surprise me because he's a criminal. So, and I do understand he murdered, I think 5 people, and I do understand that his victims' families have a right to justice. I guess the question is the death penalty justice, or is life in prison justice? What constitutes justice? And that, I think, is a conversation for a different day. But it was, I'm sure, a harrowing hour that they were trying to get an IV started for him, for both him and for the witnesses, both the community witnesses and the family witnesses, because he did have, according to the reporters that were there, there were people in the section of the viewing area is divided by a wall, and on one wall are the community observers, and then on the other side are families. And so what the reporters said was there were people on that side, and he was making eye contact with them and mouthing words to them. And so there was some evidence that he was connecting with people who were there for him. So, I mean, the death penalty is not a simple subject. It is a very complex subject, and it is subject to a tremendous amount of interpretation and a tremendous amount of subjective, emotional opinions. And my opinion is going to be very different than a lot of you. That is, and to me, that's what makes our society, the fact that we can disagree and we can have varying opinions, is what makes our democracy work. The fact that we can test one another's ideas and opinions, and test our own opinions and reality against other people's, is what makes our country great. So I encourage people to post their opinions and to disagree with me. That's what makes a horse race. So, Ladybug, do you think Chad heard about the Cheech issue? In my opinion, life without parole is the worst. Well, I don't think that anybody it within the system will have not heard of Cheech. So I am certain that Chad heard about what happened today. I'm certain that he heard that it was uh, it's Creech instead of Cheech, not Cheech and Chong. It's Creech. Anyway, I think I don't think that anybody who is within the jail or prison system will go very long without having heard about it. And I'm sure that his attorneys have given him that information. I sure would. I mean, if I were Chad's attorney, I would be letting him know that information. Because I think he has a right. I don't think he should be sheltered from it. He has a right to use that information as part of what he applies as he is considering his options. Because I don't think that a plea is entirely off the table. I think it is off the table in Chad's mind. My understanding is that he was not willing to entertain any sort of a sentence that would include him remaining in prison, which was, of course, highly unrealistic. So I think that he'll go to trial rather than take a plea. But every piece of information like this, well, if there is if I am sentenced to the death penalty, it's not a sure thing, and there's a lot of anxiety and angst that goes into that, and there will be a lot of that, and it will be a very long and drawn out and painful process. So, that might give him pause. I don't know, but it's certainly, I think, something he's entitled to know. Christina Jones, Lori, what do you think about the accusations against Alex regarding pulling the trigger? Oh, I don't think there's any doubt. First of all, we know he pulled the trigger and murdered Charles Vallow. And I don't think I think that there were a couple of places where Lori actually gave away that information. One of those was in her alibi statement, which wasn't really an alibi, but they filed it. Her alibi, notice of alibi filing, where she said, oh, Alex Baldwin, not Alex Cox, let me finish this thought, where she said in her alibi, the children were murdered in Alex Cox's apartment, and I was in my own apartment with Chad. So there was that. The question having to do with what do I think about the accusations against Alec Baldwin regarding pulling the trigger? He has adamantly denied he pulled the trigger, and he claimed that the gun malfunctioned. Now, in the testimony, there was an expert. He was actually the FBI gun expert who said, who after he admitted that he beat the gun with a hammer to try and get it to misfire, he said that in certain firing positions, so when the hammer is in certain positions, it is possible if you drop the hammer of the gun to fire the gun without the trigger. He kind of went through that explanation, and it was kind of technical, and it was a little bit sort of in the realm of it could happen. But Alex Baldwin said he didn't pull the trigger. He's been pretty adamant about that. Now, does that mean he didn't really pull the trigger? Who knows? I don't think there's any way to definitively know for sure. And one of the biggest problems is they turned the gun over to the FBI, who did some test firings and then turned around and beat it up with a hammer and disabled it. And the FBI says, well, we called local law enforcement and they told us it was okay, so we did it. And now comes out that they're, that Alex Baldwin is claiming that the gun misfired. So, and because of all the damage to the gun, I don't think there's any way to know for sure. So that's another bit of reasonable doubt that's going to creep in his trial. In Hannah Gutierrez's trial, I just don't think there's there's no wiggle room the way there is for Alec Baldwin. So good question. I'm sure it haunts him. It would haunt me. I mean, I think it would haunt any normal thinking person to know that you were responsible for someone's death, even in a horrible accident. I think it haunts people every day who drink and drive and cause an accident where someone dies, or mishandle a gun that goes off and kills someone. It haunts that person forever, and it should, even in a horrible accident. So, I mean, but a horrible accident isn't a prosecutable offense. So what the jury in Alec Baldwin's case is going to have to decide is whether or not that chain of causation, the chain of who was handling and loading the gun, breaks that causation and interferes with his ability to know the gun was safe. So he has to be able to argue, I had the right to rely on the armorer whose job it was and the second guy whose job it was to safe the gun. I had the right to say, I believe this is, I had the right to rely on the fact that I was told it was a cold gun. So that's really going to be a question for the jury. The jury is going to have to decide whether or not the prosecution proves every element of the crime beyond a reasonable doubt. And one of those elements is recklessness or negligence. Remember, in every crime, there is a mental state that you have to be able to prove. You have to be able to prove intentionally, knowingly, and recklessly or negligently is one of those mental states. So one of the elements that the prosecution has to prove is that Alec Baldwin acted recklessly or negligently, that it was negligent for him to rely on the armorer and the people whose responsibility it was, or that it was reckless. So that's going to be a little bit harder to prove than it is for Hannah Gutierrez, because it's clear her negligence, it was her job. She had one job. It was her job. It wasn't necessarily Alec Baldwin's job to safe the gun. Now, a lot of people argue, my husband, who is grew up with guns, it says you never take a gun, you never pick up a gun that you don't check it yourself. So, okay, the question is, did Alec Baldwin know enough about the rounds that were loaded into the gun to be able to recognize a live one from a dummy? I mean, those are all things that have to be brought out at his trial. But I think the argument's going to be, did he have the right to rely on that? Was it negligent and reckless on his part not to do his own safety check? So on Hannah, it's a no-brainer. It was her job, and she clearly was reckless. The question is whether or not Alec Baldwin had a responsibility to safe the gun. So any other questions? Hi, Chelsea J. I'm behind, but I want to express appreciation for Lori saying voir dire properly. Well, there is always a difference of opinion on how to pronounce that, but that's the way I was taught, and it's not something I'm going to change anytime soon. It's kind of like, how do you pronounce pro hac vice? Some people say pro hac vice. Some people, yeah. So for all those who say voir dire and all of those things, I guess that's how they learned it. But for me, it's voir dire. Ladybug Lady, just an FYI, I've followed you since your first appearance live on YouTube. Greatly appreciate you sharing your knowledge with us. I've learned a lot. I am so glad to hear that. Thank you so much. I thoroughly enjoyed the time that I was a guest on other programs, and but this has been a blast. I love interacting with all of you. I love your questions. I thoroughly enjoy and look forward to Wednesday nights. So I'm glad that you get lots out of it too, because that's my goal, is to demystify the law a little bit. And I know we're all really interested in these cases. And sometimes the most mystifying part of it is, well, what's happening in this trial? What did they just say? And so I'm really glad that I can be a part of helping everybody figure that out and sort of cut through the legalese to give you all an idea of what's really going on. Because most of the time it's, well, that's the complicated lawyer way of saying something really simple. But if you say it simply, then people aren't going to pay you a lot of money to explain it. So, so I really appreciate you all being here. Yes, we have a new quilt project. For those of you who are uninitiated, I am a quilter, avid quilter, and a lot of the people who are in our group are also quilters. And so we kind of bonded over that common hobby. And last year, before Lori's trial started, we did a sampler quilt that had different squares, and we did a quilt along. I made some instructional videos, and we did it all together. And when the quilt was done, it hung behind my head for quite a while. Well, we raffled it off. The proceeds all went to the Center for Missing and Exploited Children, and we sent it off to its new home. Terry Goyens, who is in our chat, was so generous to do all of the long arm quilting after I had pieced the top, and did a gorgeous job. And so our friend Kathy is now enjoying it at her house. So I had wanted at some point to do something that maybe a few more people could get involved in, mostly because it would be not a whole quilt, but a quilt square. So my idea was, in Japan, they fold origami cranes. And one of the things that they use them for is to honor someone at a funeral, to remember the person who has passed. And they have a tradition of folding for a funeral 1,000 paper cranes. So I have downloaded a 6-inch quilt square that is a paper pieced pattern for an origami crane. And my intention is to collect them all, to have all of you make one square, collect them all, assemble them. Terry has been generous enough to offer to do the long arm quilting. And we're going to do that for Kay and Larry. I don't know that it's going to get done before Chad's trial starts in April, but certainly it will be done shortly after that, and we'll be able to present that to them. So I'm really excited to do that, and hoping that you all will join me. I made one square. One of the things that is coming up on my to-do list for next week, along with getting the website up for our launch team, is to put up a short instructional video on how to make that square. those of you who are experienced paper piecers, it will be no problem at all. But it is a little bit different than regular piecing. You actually piece on top of a pattern. And so I'm happy to make a little segment on how you do that. The only thing I've asked is that when you make your square, please make the background black. And otherwise you can pick any fabric, any print, whatever it is, any color, because it is meant to be a celebration of color. And I think the black background will make those colors really pop. And it is meant to be as exuberant as JJ was. So I'm excited for the project, and I think that I've already had a lot of folks who've downloaded the pattern. The link to the downloadable pattern is in our show notes, and Jen has it up on the screen as well. So I want to thank everybody for being here tonight. I know that you could spend your Wednesday nights an awful lot of ways, and I want to thank you all for being here with me. Reminder that there's no show next week because I'll be traveling. And I want to thank you all for having joined us. And thank you so much for the very generous super chat, Debbie. So I'm going to say good night. I would say see you next week, but I'll see you in 2 weeks. In the meantime, if there are interesting things that come up that we need a surprise live for, you might be surprised. Good night. I didn't mean to leave completely, but you're muted.